establish a procedure for expunging certain cannabis-related convictions, standing in the name of Mr. Rankin.
Mr. Rankin, seconded by Mr. McGregor, moves that Bill C-415, an act to establish a procedure for expunging certain cannabis-related convictions, be now read a second time and referred to the Standing Committee on Justice and Human Rights. Debate. The honourable member for Victoria.
Thank you, Madam Speaker. It's an honour to rise in the House this afternoon to present my private member's Bill C-415. My bill would have the effect of expunging or erasing criminal records for the 500,000 Canadians who have records for the possession of small quantities of cannabis, which of course became a perfectly legal activity in October of this year. This is a matter of fundamental justice, and I urge all members to support this initiative. To government members, I urge you particularly to keep an open mind and to study this bill and amend it so we can move it forward as quickly and effectively as possible. As far back as 2012, of course, the Liberal Party passed a resolution, number 117, on cannabis legalization. And it's curious to note that it used the word in that resolution of elimination of all criminal records for simple possession. So I'm pleased that the Liberal Party agrees with me that expungement and not merely record suspension is what is required in this circumstance. Now, according to a report commissioned by the Department of Public Safety, fully 86% of those surveyed agreed that completely erasing criminal records for minor offences, particularly cannabis possession, was the right thing to do. And judging by the enormous outburst of editorial support that I'm pleased to have received from coast to coast, Canadians get it. They support this initiative because Canadians are fair-minded people who recognize the unfairness inherent in continuing to burden people with the effects of a criminal record for something that is now legal. Now, I stood yesterday in the House with a prominent Aboriginal leader from British Columbia, with people from the John Howard Society, and with Senator Pate, of course, the former executive director of the Elizabeth Fry Society. They all called on the government to get with this, expunge records, and not to rely, as I'll explain why it would be inappropriate to do, on the issue on merely criminal record suspension in this context. Now, Madam Speaker, I have three fundamental arguments in the short time available I would like to make. First, to challenge the government's assertion that they will be bringing on immediate pardons. The word immediate, I think, means now, and I'll explain why that's simply not possible. Secondly, I want to address the government's apparent argument that expungement is somehow reserved for only one category of past historical injustices and not things like this. Only record suspensions, apparently in their mind, is appropriate in this context. And thirdly, to tell Canadians about just how the unjust application of cannabis laws in our country has happened. I think it's undeniable that there has been an injustice. So on the first point about the timing, the government has, of course, had several years to address this signature initiative, cannabis legislation. Unlike other jurisdictions like California and Vermont, when they brought in their laws, they brought this piece in at the same time, and they suspended and automatically expunged, rather, the records for people with convictions of small quantity of cannabis. The Liberals chose not to do that. They said, now we should wait for record suspensions. Sometimes they call them pardons, and that will happen sometime soon, maybe with legislation introduced, I presume, in the spring. Of course, Madam Speaker, Canadians know there will be an election in October. They know it has to pass any initiative through both houses and be proclaimed in law. So it's likely that that won't even take place until 2020, if my arithmetic is right. I think Canadians, when they hear the word immediate, mean something different. And I would urge them to work with my bill and make it better so we can get on with the task that should have been commenced when we brought in legalization in the first place. Second argument is this arbitrary distinction between expungement reserved for something called historical injustices and pardons for something else. I don't know who is giving legal advice to the Liberals on this point. I've had the good fortune of getting opinions from Ben Berger, Professor of Law at Osgoode Hall, and noted constitutional lawyer Professor Kent Roach of the University of Toronto. And they see absolutely no distinction in law. And I see none in public policy for what the government seems to be insisting upon. Let me quote from a leading Toronto criminal lawyer, Anna Maria Enenajor, of the Campaign for Cannabis Amnesty. She said this, and I quote, "The government leaves the impression that restrictions exist on the government's ability to issue expungement for the offence of simple cannabis possession that are beyond its control. This is false. There is nothing in Canadian law that prohibits our government from issuing expungements for offences that, in their application, unjustly targeted racialized and Indigenous communities. It simply chooses not to do so. This is a policy decision." Close quote. Professor Kent Roach says this, "The Charter is the minimum, not the maximum, in terms of our sense of justice. The government's proposed pardon scheme also reveals larger problems with our pardon system, which, among other drawbacks, is conditional on future good behaviour." So, Madam Speaker, I think that there's no distinction possible, although the government wishes to make it. I urge them to keep an open mind so we can do what's right for Canadians. And that takes me to the third point. The application of this law is an historical initiative to address historical injustice. Now, it is a fact, and I commend the government for acknowledging this, that across this country, Black and Indigenous people have been disproportionately burdened with criminal records for small quantities of possessing small quantities of cannabis, making it, therefore, for these people who often already are more marginalized and impoverished citizens, unable to get their foot on the social ladder. Why, Madam Speaker? Well, because they have a record. And that means you're last in line when you want to get that rental apartment. You're last in line when you want to get that job, and you have to fill out an application that says something like, or says orally to them, "Do you have a criminal record?" And they have to say yes. If that record were expunged, as my bill would do, it means you can honestly answer that you do not, because it would be deemed in law that you do not have a criminal record. Imagine how many thousands of impoverished Canadians we could assist by doing the right thing. Now, you know, jaywalking is not an offence under the Charter. But if you go after 9 out of 10 people who are Black or Indigenous for jaywalking, then that is a Charter violation. And what's happened in this country is, and again I commend the government for acknowledging this data being valid, if you are Indigenous in Regina, you are 9 times more likely to be charged and have a record for cannabis than non-Indigenous people. 7 times more likely in Vancouver. And if you're Black in Halifax, you're 5 times more likely to be charged and have a record, and 3 times more likely if you live in Toronto. This is wrong. This is Canada. We should fix that and let these people get on with their lives. So I want to address head-on the government's argument about record suspensions. They choose to call it pardons. It doesn't do the job, Madam Speaker. It doesn't do the job. What is the difference between a pardon and expungement? An expunged record is erased. It's completely destroyed. Under my bill, the offence is deemed at law never to have happened. So a person whose record has been expunged can truthfully say on that job application, "No, I don't have a criminal record." That makes all the difference. What about a pardon? Pardon merely reclassifies the record. It may still be released and even revoked in the future. Most importantly, with a pardon, an individual can still face those obstacles I talked about. Furthermore, a pardon talks about forgiving by implication and not expungement, which would be an acknowledgement of the historical injustice about how our cannabis laws have been applied in our country. Cannabis amnesty has been for a long time a policy of the NDP. Since 2004, we've been calling for amnesty for people with records for cannabis possession. My colleague, the member for Vancouver Kingsway, who's done excellent work on this file, introduced a motion in the House asking the government to immediately pardon all criminal records for simple possession. The government said no. So let me go to the argument that I've heard the government use as recently as this morning, Madam Speaker, and it goes like this. You're wrong. Pardons, you have to, when that landlord or that employer asks you, do you have a record, They're supposed to ask this question: have you ever been convicted for a criminal offense for which a pardon has not been granted? Now, Madam Speaker, they say, well, if there's been a violation of that, you can go to the Human Rights Branch or the Human Rights Tribunal in your province. Madam Speaker, I don't know whether they have been dealing with people in inner city. I used to do legal aid in downtown Toronto. People who are not literate, who don't speak English. These are people who have enough trouble already. Do you think they're going to get a lawyer with legal aid in this world, being so scarce, to go and take that to the Human Rights Branch? I don't really think so, Madam Speaker, and neither does Samantha McAllisey, who's doing her PhD on this very topic at Carleton. And she has worked in the inner city of Ottawa with John Howard Society for many years. And she says that many people struggling with criminal records can often have barriers like literacy or language, making these formal complaints to the human rights codes very daunting. She says requiring individuals to muster through a complaint process in order to access employment, housing, or any other social domain seems quite ridiculous. People with criminal records already face enough barriers in the community and are often already doing everything they can to get by day, close quote. Madam Speaker, even if the government is right, why wouldn't they go far enough to complete the job with expungement? Even if there's a legal, technical reason for being right, which I urge upon the government is not the view of the leading criminal and constitutional lawyers I've consulted, even if they're right, why wouldn't they complete the job? I was so proud to have stood in this House when another expungement initiative took place, not long ago, Bill C-66. It was the expungement of what the government termed, and I agree, historically unjust convictions for people convicted in the past of same-sex sexual activity. Yet thousands of racialized and marginalized people also have been treated unfairly in the past. I've demonstrated that. The government accepts it. They have these barriers to renting jobs, renting apartments or getting a job. And I've also had mothers from Saskatoon crying on the phone to me that their child with a couple of joints, busted a couple of years ago, can't coach the soccer team. Because there's these vulnerable people initiatives that require people to not have records for reasons we well understand, dealing with children and so forth. And their lives are also affected by this. So after years of injustice, why would the government settle for a process that won't fully relieve the burden of a criminal record? The only way to right the wrong and finally give the 500,000 Canadians a fair chance is expungement, to erase these records for simple possession. So, Madam Speaker, I think the evidence is pretty clear. The argument about pardons may be good in theory, but in practice, people in the real world don't always ask those precise questions that the government says they should be, landlords and employers should be asked. Have you ever been convicted of a criminal record for which a pardon has not been granted, that magic incantation? The real world in downtown Ottawa, we were told yesterday, the real world in downtown Toronto is people don't always ask those questions. And therefore people can't get on with their lives because they have a criminal record and they're already the poorest among us often. And they're disproportionately Indigenous and they're disproportionately Black. Canadians, it's just simply the right thing to do, Madam Speaker. Why the government didn't do it at the time like other jurisdictions they modeled their legalization on, I don't know. But it's time to do it now, and it's time to do it right. A half measure isn't good enough for Canadians. Expungement is the answer. Record suspension doesn't do the job. Let's get on with it. I urge the government, I urge all members to do the right thing and support my bill in this House. Thank you.
Questions and comments? Questions et commentaires? The Honourable Parliamentary Secretary to the Minister of Families, Children's and Social Services Development.
Thank the member opposite for the presentation, and I agree with virtually every point that the member has made, in particular in the impact of racialized youth, and in particular on the Black and Indigenous communities of this country. There is a different way in which they've been policed, and the court system, the incarceration records prove it without a shadow of a doubt. The concern that has been expressed to us, and I'm considering supporting the private member's motion because this is a significant issue in many of the communities I represent. But the issue is this, is that not every one of the charges is equal. Not every one, I mean, they have definitely been policed differently, definitely been convicted differently, managed by the courts differently. But in some cases, the charges are part of a larger criminal process and a larger criminal set of charges, and expunging the record has an impact on sentencing, has an impact on public safety. And so I would ask the member opposite just to reflect on, if you start pulling out some of the convictions on very serious charges where the possession charge is incidental, you may shorten criminal sentences and you may shorten certain sentencing provisions, and that may create complications around public safety and how they handle that.
The honourable member for Victoria.
Well, first of all, I'd like to sincerely thank the member opposite for keeping an open mind and considering support of my bill. I appreciate that very much. And I have to say that his recognition of the historical injustice and the disproportionate impact on Indigenous and Black Canadians is something we both have to work harder on, and this House has to work harder on, and this is an opportunity to take a step in that direction. It is true that often convictions for records for small quantities of cannabis go hand in hand with other convictions and the like, and there's been such things as plea bargains, all of that we need to acknowledge exist in the real world. You know, in California and other places, the expungement is automatic. We don't have to have these applications. Unfortunately, as a private member's bill, I can't do that, as you know, Madam Speaker, but we can't require the government to spend the money. If I had my druthers, I would have the government actually take action and automatically expunge the records for things that are now perfectly legal. I think there is a problem. There's a technical issue that can be dealt with. I'm not sure why we can't do it. The San Francisco District Attorney's Office actually has a software program to go through and do this work. I don't see why we can't figure it out here.
Questions and comments? The honourable member for St. Albert, Edmonton.
Thank you, Madam Speaker, and I thank the member for Victoria, who I have the privilege of serving on the Justice Committee with. The government has taken the position that they support a so-called expedited pardon process, but they haven't said when. They haven't defined what exactly that will look like. In 2013, the Prime Minister bragged about how he consumed marijuana. And yet, as the honourable member noted, 500,000 Canadians have criminal records. Does the member not see a double standard?
The honourable member for Victoria.
Well, I want to start by saying I appreciate the question from my honourable friend with whom I work. I think he'd agree very effectively on the Justice Committee. It's an honour to serve with him there. Both of us are vice chairs of that committee, and he's a real asset to it. An expedited pardon process might come along, and the government's going to tell us it's going to be free and it's going to be fast and so forth. It doesn't do the trick, Madam Speaker. It's under-inclusive. I don't know why they wouldn't go, if there's any doubt at all, why they wouldn't embrace the right thing and expunge. As for the Prime Minister's acknowledgement, I think there's an important point here. There was a stigma at a time for same-sex sexual activity. That's no longer the case. There was a stigma for cannabis possession in the past. That's no longer the case. Otherwise, our Prime Minister wouldn't have acknowledged that he did this in this House. The problem, Madam Speaker, is simple. That person did not get caught. Thousands and thousands of particularly Indigenous and Black Canadians did get caught, and they're suffering. He's not. We're not. We should do the right thing and get on with it. That's right.
Resuming debate, reprise de débat. The Honourable Parliamentary Secretary to the Minister and to the Prime Minister, and to the Minister of Border Security and Organized Crime.
Well, thank you very much, Madam Speaker. It's a pleasure to rise today to speak to Bill C-415, an act to establish a procedure for expunging certain cannabis-related convictions. I'd like to first thank the member for Victoria for his hard work and strong advocacy on this issue. I know that he's spoken numerous times with the Minister of Border Security and Organized Crime, Madam Speaker, about this issue on several occasions. It's something we very much appreciate. It's clear the member shares the conviction that some changes need to be made with a new cannabis control regime in place. Madam Speaker, for nearly a century, the criminal prohibition of cannabis failed to protect youth and led to the highest rates of cannabis use amongst our kids in the world. It also led to billions of dollars in profit for organized crime and created an unhealthy and unsafe situation in all of our communities. And that is why, Madam Speaker, we replaced the criminal prohibition with a far more effective and proportional system of comprehensive cannabis control. And while there are no turnkey solutions, Madam Speaker, to righting the wrongs that resulted from that regime, there are now steps we can take to address them. Bill C-14 would create a method to expunge cannabis possession convictions, regardless of quantity, that are no longer an offence under the Cannabis Act. It proposes a no-charge, application-based process that would allow applicants to provide sworn statements to prove eligibility. It does not, however, require them to prove attempts to obtain official supporting documents in doing so. This bill also proposes that expungement must be granted so long as the review by the Parole Board of Canada does not reveal any evidence that the activity in question was prohibited under the Controlled Drugs and Substances Act or any other act of Parliament. And Madam Speaker, the approach proposed in Bill 14 is similar in form to another bill this House passed not long ago, but the nature of the convictions that are proposed for expungement is quite different. Bill C-66, the Expungement of Historically Unjust Convictions Act, received royal assent in June of this year, Madam Speaker. That legislation was introduced on the occasion of the historic apology to the LGBTQ2 community for decades of state-sponsored systemic discrimination and oppression. It put in place a new process to permanently destroy records of convictions for offenses involving consensual activity between same-sex partners that would be lawful today. The government passed that law so that expungement could be available as a tool to correct a profound historical injustice where the offence had been ruled unconstitutional or contrary to the Canadian Human Rights Code. However, there are substantive differences between the nature of those offences and cannabis possession, which courts have never found to be constitutionally invalid. That said, clearly we agree, Madam Speaker, with the member for Victoria that individuals who previously acquired criminal records for some possession of cannabis should be allowed to shed the burden and stigma of that record. And that's why, Madam Speaker, when the Cannabis Act came into force on October 17th, the government announced its intent to introduce legislation which, once in force, would allow individuals to apply for a record suspension as long as they have completed their sentence. The 5-year waiting period would be waived and would be immediately eligible. Finally, Madam Speaker, the unfair $631 fee put in place by the Harper Conservatives would also be waived and available at no cost to the individual. Madam Speaker, these records have had a disproportionate impact, as my honourable colleague from across the way had mentioned, on our youth from poor communities, racialized communities, and of course, Indigenous communities. Many Canadians also have a criminal record as a result of some youthful indiscretions and now lead otherwise exemplary lives, Madam Speaker. This proposed measure will make affordable record suspensions available to those individuals. It will give them the opportunity to remove the stigma and burden on their lives that results from a criminal record. I'll point out at this point, Madam Speaker, that thanks to the motion from the member for St. John's Rothesay, the Standing Committee on Public Safety and National Security has been instructed to undertake a study of the record suspension program formerly known as pardons. The idea behind this, Madam Speaker, would be to firstly examine the impact of a record suspension to help those with a criminal record reintegrate back into society. Secondly, to examine the impact of a criminal record suspension fees and additional costs associated with the application process on low-income applicants. Thirdly, to identify appropriate changes to fees and service standards for record suspensions, and to identify improvements to better support applicants for a criminal record suspension. The committee would be able to study improvements that could be made to the process surrounding record suspensions. But I'm pleased to note that the government's announcement of intent with respect to the legislation on record suspensions for some possession of cannabis reflects the desire to reduce the kinds of barriers reflected in that motion. Madam Speaker, protecting Canadians is our #1 concern. We do that by implementing evidence-based criminal justice policies that are proven to support rehabilitation, prevent crime and victimization, and keep our citizens and communities safe. The government's announced intent to introduce new legislation is in keeping with that principle, Madam Speaker. And aside from the differences and the proposed approaches. I'd like to also point out that Bill C-14, Madam Speaker, is flawed as it's currently written. Under the bill, the acceptance of a sworn statement to prove eligibility without having to demonstrate attempts to obtain official documents risks that expungement could be ordered and records destroyed for ineligible individuals. For example, those convicted for possession of far more dangerous controlled substances like cocaine. As currently written, indeed, most individuals would not be eligible to apply, as the bill requires that the activity be legal today. All cannabis obtained prior to coming into force of the Cannabis Act, Madam Speaker, was illicitly possessed, and the possession of illicitly obtained cannabis remains an offense today. So, Madam Speaker, I'm grateful that many in this House feel that those previously convicted for some possession of cannabis should be allowed to participate meaningfully in society. They should have access to good, stable jobs. They should have access to housing and education and the ability to participate in the community, Madam Speaker. For far too long, many thousands of Canadians have faced barriers to those necessities simply because of possessing cannabis. But values have shifted, and we've recognized the failures of prohibition. And we've now, for over a month into legalized and regulated cannabis, see the positive impacts of that action. What we do now to make things as fair as possible for Canadians must be done carefully, and it must be done diligently. And I very much look forward to taking the next steps to help people turn their lives around. And once again, I'd like to thank the member opposite for his views on how we can do so, and I'd like to thank you, Madam Speaker, for the opportunity to address this issue today.
The honourable member for St. Albert Edmonton.
Thank you, Madam Speaker. I'm pleased to rise on Bill C-415, a private member's bill introduced by my friend, the honourable member for Victoria. It is legislation that would expunge the criminal records of Canadians who were convicted for the minor possession of marijuana. Madam Speaker, the fact that the honourable member for Victoria has had to bring forward a private member's bill around this issue speaks to the fact that once again the Liberals have dropped the ball on the issue of marijuana legalization. You know, Madam Speaker, the Prime Minister during the last election made it as a central platform commitment to legalize marijuana. We, on this side, disagreed with the position of the Prime Minister, but elections have consequences. And enough Canadians voted Liberal, and the Prime Minister was elected, and therefore it was not a surprise that the government decided to move forward with the legalization of marijuana. But it's one thing to have an idea and another to actually implement that idea. And what we have seen, Madam Speaker, is time and again this government has not had a plan when it comes to going about implementing the enforcement and implementation of marijuana legalization. Madam Speaker, this government had no plan with respect to a public awareness campaign. That was, by the way, Madam Speaker, a key recommendation of the government's own marijuana task force headed by former Deputy Prime Minister Anne McClellan. And for good reason, Madam Speaker, because there are serious health risks associated with the consumption of marijuana, particularly for young Canadians, those 25 and under, in terms of the development of brain development impairment, among other issues. And so, Madam Speaker, where was the government's early and sustained public awareness campaign? Well, Madam Speaker, there was no public awareness campaign. The Liberals simply dropped the ball.
Non-existent.
Then, Madam Speaker, the Liberals had no plan around keeping Canadians safe from drug-impaired drivers. Oh, sure, they introduced Bill C-415, legislation that amended the criminal code to bring in drug-impaired driving laws. But it's one thing, Madam Speaker, to pass a law, and quite another to give law enforcement the tools and resources that they need to enforce the law. 3 years ago, there were about as many drug recognition experts as there are today. This despite the fact that law enforcement, Canadian Chiefs of Police, the Canadian Police Association, among others, have been begging and pleading with this government to provide the resources so that they can hire more drug recognition experts, which are essential to keeping our roads safe. But instead of listening, the government once again just dropped the ball. Madam Speaker, Bill C-46 imposes per se limits around THC. The problem with that, Madam Speaker, is there isn't necessarily a clear correlation between THC levels and drug impairment. It's a pretty big problem, Madam Speaker. But instead of addressing concerns that were raised about the government's approach, they just shrugged their shoulders, and as they dropped the ball yet again. Madam Speaker, Bill C-46 provided for roadside screening devices to detect drug impairment. Madam Speaker, the problem was that there was no screening device that was approved until virtually on the eve of the date that marijuana became legal in Canada. So unreliable is this device that most law enforcement agencies across Canada are not acquiring the device. They're waiting for another device, a more reliable device, to be approved. So, Madam Speaker, yet again, the Liberals dropped the ball. And so, Madam Speaker, given a record like that, is it any wonder that when it comes to dealing with the more than 500,000 Canadians who have criminal records for minor possession, that the government has no plan? Madam Speaker, they just, again, dropped the ball. You know, the government talks about a so-called expedited pardon process, but, Madam Speaker, the government has provided no indication about when they plan to introduce legislation. The timeline is completely vague. What that expedited pardon process would look like, the government has refused to provide details. In fact, it seems that while making a commitment to move forward with a pardon process, the Liberals would prefer just not to talk about it at all if they could get away with it. And it wasn't until the member for Victoria called on the government to take action that the government announced that they would move forward with some sort of undefined pardon process. And Madam Speaker, as the member for Victoria rightly points out, other jurisdictions, including California and Vermont, did implement an expungement process at the same time that legalization came into effect. Now, Madam Speaker, while one can argue about the merits of expungement versus a pardon versus providing no blanket process at all, what is unacceptable is that the government has refused to be straight with Canadians and honestly tell Canadians where they're going to go. Instead, they just don't have a plan. And so, Madam Speaker, it is I have to say, a little bit rich that the government has dragged their feet, that the government would prefer not to talk about this issue, given the Prime Minister's own personal history. The Prime Minister in 2013 bragged about how he had consumed marijuana, how he used marijuana. He relished the attention that he got upon making that pronouncement. And of course, the Prime Minister wasn't caught. He wasn't charged. He wasn't convicted. He doesn't have the burden of a criminal record. The Prime Minister lives a pretty privileged life. But as the member for Victoria pointed out, there are 500,000 Canadians, including many marginalized Canadians, who are burdened with a criminal record. Burdened with a criminal record for committing an offense that today is perfectly legal. And so, Madam Speaker, I think the time has come for the government to be straight, to come forward and come up with a plan, because to date they've done nothing more than drop the ball. Canadians deserve better. Thank you, Madam Speaker.
Resuming debate, the honourable member for Cowichan-Malahat-Langford.
Thank you very much, Madam Speaker. It's indeed a very great pleasure to rise today to debate Bill C-415, brought in by my honourable colleague and friend from Victoria. We both hail from Vancouver Island, and I really just very much admire the work that he's put into this bill, because it's not very often that you get to debate a private member's bill in this place that really has such significance for changing how we approach the criminal law and acknowledging past wrongs. You know, one other private member's bill I can reference, which I think had a major impact, was Bill S-201, which was brought in by Senator James Cowan, which recognized genetic non-discrimination. And the Liberal cabinet had a position against that bill, but virtually the entire Liberal backbench rose up and disagreed with the cabinet and voted in favor of that bill. And so with the combination of the Liberal backbench, the Conservatives, the New Democrats, we actually passed that bill. It received royal assent. And I very much implore my Liberal colleagues, I know some have raised some concerns with this bill, but I implore them to look at what is being attempted through this bill. They may not think it's perfect, but at the second reading stage of a bill, we're acknowledging the intent of the bill. And I think very much that if they look into their hearts, they will find some worthiness in at least sending this bill to the Standing Committee on Justice and Human Rights, where we can hear from departmental officials, where we can hear from expert witnesses, many of whom the member from Victoria has already quoted. And that's where we can actually look at the language, the technical jargon of the bill, to see if some of those concerns can be addressed. But let us at least send this bill to committee, because I think this is a very important moment. Madam Speaker, last year I had the pleasure of giving the NDP's response speech at second reading to Bill C-45 in my capacity then as the justice critic. And you know, I acknowledge the bill was not a perfect bill, and there was a lot of very fulsome debate on the merits of that bill. I think my colleague, the member for Vancouver Kingsway, said it right when the bill C-45 didn't really legalize cannabis; it just made it less illegal, because the possession, there's some very strict limits that even if you step outside of those bounds, the full weight of the law is going to still come upon you. But nevertheless, I think even my Conservative colleagues can realize that there has been a sea change in public opinion in Canada with regards to cannabis possession. There was a very real realization that the continued criminalized approach to cannabis possession was wrong. Far too many people were suffering under it, and in fact the continued criminal approach was actually causing more harm than the prohibition of than the actual use of the drug itself, and there was that recognition. And indeed, when you look at many of the arguments that Liberal members made in support of C-45, not the least of which was the Minister of Justice, one of the big reasons they cited was the fact that thousands of Canadians end up with criminal records for a non-violent minor cannabis offence each year. In fact, I'll quote her, Madam Speaker. In her second reading speech on C-45, the Minister of Justice said, and I quote, "A majority of Canadians no longer believe that simple possession of small amounts of cannabis should be subject to harsh criminal sanctions, which can have lifelong impacts for individuals and take up precious resources in our criminal justice system. Our government agrees that there is a better approach," end quote. Madam Speaker, I could not agree more with what the Minister of Justice said last year during the second reading debate on this. Now, there are roughly 500,000 Canadians who have criminal records for cannabis suspension or cannabis possession. So that means, Madam Speaker, if you took a room of 60 people, one person in that room is probably going to have a record for cannabis suspension. And, you know, I think when we acknowledge that that's pretty far-reaching, the consequences that it indeed has. We know that it has affected marginalized and racialized populations disproportionately more than average Caucasian Canadians, and that is borne out by the evidence collected in each province and many of our major cities. But also another big issue, too, is that, you know, this government came to power with a promise to legalize cannabis, and in fact it was adopted in a 2012 Liberal Policy Convention. So I think the Canadian public has known for quite some time that this was coming. Like my friend, the member for Edmonton, St. Albert Edmonton said, elections have consequences, and the Liberal government did fulfill that one promise. However, I have issue with the length of time that it took. We needed the task force to present its report. We then finally had C-45 introduced in April of 2017, and it did receive royal assent and came into force only on October 17th of this year. There was plenty of time for the Liberal government to deliberate on this subject, on the consequences that criminal possessions have for people's lives, where you have this strange binary situation where a person who possessed cannabis on October 16th received a criminal record, but a person who had it on October 17th was perfectly fine. It is quite amazing what has happened in this country. Like you can now possess up to 30 grams in public. People can now grow their own plants, because even though there are still very real consequences with the over-consumption of cannabis, whether it's getting into the hands of children, I think we can very much agree that the continued criminal approach to the issue was wrong. It was using up precious resources, and it was in no way effectively dealing with the problem. And Madam Speaker, when you look at the intent of C-415, I very much admire the word expungement, because it has an air of permanence about it. It is very much different from a record suspension, because as the member for Victoria very clearly laid out, a record suspension is simply setting aside the record. It does not protect the individual in any way from having that reapplied sometime in the future, and indeed, you know, they very much have to prove that they are worthy of its happening. And expungement allows that individual to actually truthfully answer a question that they do not have a criminal record, because expungement makes it as if it never happened in the first place. Now, I know that, and when you look at the statistics, Madam Speaker, specifically with reference to Indigenous people in Canada, in Vancouver, Indigenous people were 7 times more likely than white people to be arrested. In Regina, it was as high as 9 times. So if we're trying to address a historical wrong, a very real case of social injustice, I think expungement is absolutely the way we should be going. And Madam Speaker, I know the Liberals have raised concerns. They have said that they wish to reserve expungement for activities that have been found unconstitutional. And the Parliamentary Secretary made reference to Bill C-66, which absolutely every member in this House was in supportive of. But The member for Victoria, I have to repeat this, it was clearly outlined that the reserving expungement for activities that have been found unconstitutional is simply an arbitrary distinction. It has no legal or principled foundation. This is basically a government making up its own rules, and I asked them to point to any specific case law that underlies their arguments for this, because trust me, Madam Speaker, they will not be able to find that. They also would like to say that pardoning people will work because they're going to make pardons free and immediate. I appreciate the fact that the application process will be removed and that the fee will be waived, but right now the only legislation that actually exists on the books to address this issue, right now at the very end of 2018, 3 years into this government's mandate, is the member of Victoria's Bill C-415. And they also, Madam Speaker, agree that the process needs to be fair, but they have other doubts about the bill. This bill has been consulted widely with academics and members of the legal community. I again appeal to my Liberal colleagues to not throw the baby out with the bathwater. If they do have difficulties with the technical aspects of this bill, with the language, surely they can understand the intent behind this bill. Surely they can find it within their hearts to send this bill to the Standing Committee on Justice and Human Rights, where we can do the necessary amendments so that it comes back to this House, reported back to this House in a form that they can support. So, Madam Speaker, I look forward to voting on this bill. And again, I congratulate my friend and colleague from Victoria for bringing in this fantastic piece of legislation.
Resuming debate, the Honourable Parliamentary Secretary to the Government House Leader.
Madam Speaker, I believe that there was going to be another member from the opposition that wanted to be able to speak to the legislation.
So the honourable member would like to move over his spot, is that correct?
Opportunity to be able to speak, Madam Speaker, and yield the floor to another member, if that would be okay, if we have unanimous consent.
Unfortunately, I have already recognized the member, unless he doesn't want to speak or he only wants to speak a short time.
Just speak a short.
The Honourable Parliamentary Secretary.
Yes, thank you, Madam Speaker. I'll just keep my remarks relatively brief. I understand that there may be another speaker that wants to speak this afternoon on the legislation. I've listened to my colleague and friend across the way, and at first brush, it's quite understanding why it is that he's brought forward a C-415. And when I was listening to the member talk, Madam Speaker, about the difficulties of some being able to express themselves versus a pardon as opposed to an expungement, and I was really quite intrigued on that. And I guess in principle, the thought that came across my mind was there are many different sorts of activities that take place, criminal activities that take place, where a pardon has been issued. And I suspect that in many ways that the same challenges, in principle, would be there for those other individuals that have a pardon that's already in place. So if one wanted to be somewhat consistent, one could ultimately argue what would then be the value of having pardons. At the end of the day, Madam Speaker, I do believe that there is value to pardons. The minister has talked about issues such as being quick, free, no waiting times. This is, in fact, a commitment in which the government has made with respect to pardons. Pardons are, for all intents and purposes, something that's kind of packaged away, put in a box, never again to be reopened, unless, of course, there is another criminal activity that takes place by the individual in question. At least that's my understanding of the situation. And that's why I was somewhat intrigued by his comments when he said, well, what about the individuals that would find it difficult? And he used the example of an application for a job. And I'm very sympathetic to that particular argument. And unfortunately, there wasn't enough questions and answers, and that's what I would have liked from the member to provide an answer to me on that particular point. And it's more, as I say, the principle of the matter. I think that we've gone a long way, Madam Speaker, in recognizing at the end of the day, how far we have come in the last number of years. We have a Prime Minister that saw a significant social issue that affects millions of Canadians, and I think in a very responsible fashion in working through the ministers, and indeed most members of this House, we were able to, in essence, bring forward the legalization of cannabis. And, you know, I can say since it has been legalized, to the very best of my knowledge, Madam Speaker, I have not had one issue or concern related to it since it has actually been legalized from my constituents thus far, Madam Speaker. Given the very nature and the magnitude of the change that has been put into place, I see that as an example of just how well the government, in working with the many other stakeholders, because it's not just the government of Canada. We have to recognize that we have other jurisdictions, in particular our provinces and territories, and there was a great deal of effort with first responders and many other stakeholders to ensure that the launching, if I can put it that way, Madam Speaker, of a responsible policy, social policy put in place was in fact done in the fashion in which it was, and I think that as a society that we have really benefited by the legalization of cannabis. Now, at the end of the day, Madam Speaker, there's a lot more that I would like to be able to say, but I understand that there is a member across the way that also was hoping to be able to speak, so I'll end my remarks at that.
Resuming debate, the honourable member for South Okanagan, West Kootenay.
Well, thank you, Madam Speaker. And to answer the member's comment about pardons versus expungements, expungements can be used and should be used when there is a historical injustice in how a criminal record was obtained. You can use pardons for any criminal record, but expungements are what we need for those criminal records that came about because of a historical injustice, and I'll talk about that in my speech here. And I'd first like to again thank the member from Victoria for bringing this important bill forward. I think it's something that Canadians are looking forward to, Canadians want, and I think he is stepping into the breach where the government has failed to go. And even though they had plenty of time to get ready for this, we've been planning on this, you know, the legalization of marijuana for many years. And I can start off by saying, and this is unlike, it's obviously true in many ridings, you know, there's a lot of people in my riding that used cannabis before it became legal. You know, we all carry out kind of unofficial polling when we go door to door, and one of the things you notice when you go door to door in my riding is how many people use cannabis. It's quite a popular thing in my riding. You know, it's not everybody that's doing it, but you notice how many people do it, and it's not just people of color, Indigenous people. It's everyone. It's business people, but it's the whole point of this bill, this expungement, is that in the past, the arrests for simple possession of marijuana have been disproportionately handed out to people, marginalized Canadians, young Canadians, Black Canadians, Indigenous Canadians. These are the people that have suffered by far the most for this, and this is one of the reasons that expungement is much more appropriate than a simple pardon. So, as other people have said, many people in Canada have a criminal record simply because they were found in possession of marijuana, something that we now say is completely fine, is completely legal, shouldn't have happened before. let's get on with it. 500,000 Canadians, Madam Speaker, and some people suggest that it might be as high as over 900,000 Canadians. This is not something that is relegated to some dark, criminal backwaters of Canada. This is the bulk of Canadian society. And it leaves them with a criminal record. They can't cross the border. They have difficult finding work in many cases. They can't even volunteer to work. A lot of times when you want to coach a soccer team for your kid's school, they demand a criminal record check. Yeah. You can't do that. And so it really affects the lives of Canadians that we now say have really done nothing wrong. And as I said, we've had a lot of time leading up to this. The government had a lot of time to prepare its legislation. Other jurisdictions, California, Delaware, Vermont, now I think North Dakota's moving in this direction. They're all bringing in expungement provisions into their legalization legislation. But this government didn't. They didn't, we've been pressing them to have something like this since we began sitting in this parliament. And now they say, well, maybe next year they'll bring in legislation that it'll make it easier for people to apply for a pardon. But I just want to go back to this point about, it's really marginalized Canadians that have been hit hard, and that's why expungement is the way to go. Yep. And as other people said, if you're black in Regina, if you're Indigenous in Regina, you're 9 times more likely to be arrested on simple possession. 7 times more likely in Vancouver. If you're black in Halifax, you're 5 times more likely to be arrested, 3 times more likely in Toronto. So these simple possession arrests disproportionately affect people of color, Indigenous people, young people. And, I can quote back members of the government, what they feel on this. The Prime Minister said people from minority communities, marginalized communities without economic resources are not going to have that kind of option to go through and clear their name in the justice system. That's one of the fundamental unfairnesses of this current system that affects different communities in a different way. That's the Prime Minister. Minister of Border Security says the failed system of criminal prohibition that has resulted in the criminalization of hundreds of thousands of Canadians and contributed to an unjust disparity and impact on vulnerable communities. The Minister of Public Safety says the law as it stands today has been an abject failure. The MP from Hull-Aylmer, we do know that black Canadians have been disproportionately charged with and are imprisoned for possessions of small amounts of cannabis. So, there's, much of the cabinet admitting that this is what has been going on, and this can only be justly dealt with through an expungement, a simple expungement of all those criminal records so these people can get on with their lives and get work. Cross the border. In Toronto, 15% of people on social welfare says that a need for record suspension is a key barrier to getting work. We all want those people to work and be, take part in this economy, this society, but that's the barrier they're facing, and only an expungement would help that. I see I don't have much time left, so I would say that, as I say, the government's going to bring in, they say they're going to bring in pardons. Right now that I'm running out of time, I'll just say, Madam Speaker, that... I was going to say to the members, he's going to have 3 minutes left the next time that this is before the House, so he has about 30 seconds if he would like to wrap something up in 30 seconds, and then he would still have... the member from Victoria for bringing this forward, and I hope that everyone here supports this and we can send it to committee for further study.
Therefore, the member will have 3 minutes left when this matter is before the House again. The time provided for the consideration of private members' business has now expired, and the order is dropped to the bottom of the order of precedence on the order paper.